video, we're going to talk about how to structure an answer to a California bar exam essay question. I'm going to give you some general tips and also use the July 2019 civil procedure essay as a specific example of how to structure an essay. You may find it helpful to briefly review that essay question, which you can find in the accompanying handout before watching this video. To begin, I want to give you a few general tips for structuring an essay answer that will help you achieve a high score. First, remember who your bar exam grader is. The State Bar of California hires attorneys to grade the essays, and they typically work off a checklist or a rubric when determining whether and how to assign points to an essay. So, unlike a law school professor who might assign points for a discussion of something unexpected or maybe even somewhat irrelevant, a bar exam essay grader probably wouldn't know how to assign points to that discussion. So instead, they're looking for certain things in your answer. Also, the graders are reading hundreds of essays. So the more organized your answer is, the easier it will be for the grader to read, and the more likely the grader is to assign a higher score. The next point is that because the graders are grading so many essays, they probably know what they're looking for in an answer after they read a few answers to the same essay. So they probably start to read subsequent answers quickly and even just skim the answers. That means that it's important to bold or underline keywords or language so that that language quickly jumps out at the grader. This is especially true for rule statements that have key language, such as the rule for specific personal jurisdiction, which looks to whether the defendant engaged in such minimum contacts that it would not offend traditional notions of fair play and substantial justice. If you can recite that key language, you should bold and or underline it so that it jumps out at the grader and the grader can quickly see that you are very familiar with the topic. Third, remember that graders value organization. This goes back to the point that graders are reading lots of essays and they probably just start skimming the answers after a while. If your answer is well organized, it will be easier for the grader to read and easier for them to assign points to your essay. It is crucial that you use IRAC to organize your answer. This includes a heading for the issue and then separate paragraphs for the rule, analysis, and conclusion. If you look at the released high-scoring student answers to the California essays, you'll see that these students almost always use this formula to organize their answers. The final tip here is do not worry about writing eloquently. California essays can include as many as 30 sub-issues in a single essay. It is so much more important that you state the rule, analyze the facts, and reach a conclusion for each of those sub-issues than it is to make sure that your writing flows eloquently. It is perfectly fine if your writing feels choppy, especially if you're breaking it up into those pieces of the IRAC as we recommend. You don't need to worry about things like transition sentences because the graders will not deduct points for choppy writing. Now let's talk about how to put these tips into practice and how to approach a bar exam essay question. To start, you may find it helpful to read the call of the question first. As you're practicing, try doing some essays where you read the call of the question first and then some where you don't read the call of the question first. See if one approach works better for you. We generally find it helpful to read the call of the question first for the essay questions, so our advice is to start there. Sometimes the call of the question is specific, and it will help you identify what issues to address, and so when you read the facts, you'll know what facts to watch out for. Now, I will say this is not always the case. California is notorious for using open-ended questions, such as what arguments will each party raise? Or identify all the legal theories that the plaintiff may pursue. And so for this type of question, the call is not as helpful, but it doesn't hurt to look at the call of the question first, just in case it does provide some guidance. I mentioned that we'll look at the July 2019 civil procedure question as an example. This essay includes a pretty specific series of questions at the end. It says, number 1, how should the court rule on Priscilla's motion to compel further responses to her interrogatories to Grocery? Discuss. Number 2, how should the court rule on each of Grocery's motions to compel? Discuss. Number 3, was Grocery's response to Priscilla's interrogatory about its experts proper? Discuss. And number 4, should the court sustain Grocery's assertion of privilege with regard to Xavier? Discuss. From reading the call of this question, you can see that the subject is civil procedure. More specifically, the issues are about discovery, such as interrogatories, motions to compel, and expert witnesses, and also privilege. The call of the question also identifies that you should focus on Priscilla's motions to compel, Grocery's motions to compel, Grocery's response to Priscilla's interrogatory, and Grocery's assertion of privilege while you're reading the facts. Keeping this in mind will allow you to focus your attention as you read the fact pattern and find those facts that are exactly the things that the question is asking about. As you're reading the facts, you may even want to underline or notate the relevant facts for each part of that question. The facts for this question say, in 2015, Priscilla was shopping at Grocery when a very large display of bottled soda products fell on her, bruising her head and entire body. She filed suit in federal district court against Grocery for negligently maintaining the display and sought damages for medical expenses, pain and suffering, and lost wages. Grocery recognized that jurisdiction was proper and filed an answer denying liability. Accompanying the complaint was a set of 26 interrogatories, which read in part, number 25, please provide the names and addresses of every Grocery employee who worked on construction of the soda display and every soda company employee who did so. And 26, please provide copies of every training manual Grocery has used in training its employees. Grocery responded, objection, these interrogatories are flawed. Upon receiving this reply, Priscilla filed a motion to compel further responses. Grocery made 2 discovery requests asking for A, an order requiring Priscilla to submit to mental and physical examinations, and B, all of Priscilla's tax returns since 1995. Priscilla opposed both discovery requests, and Grocery filed motions to compel. Before Priscilla filed her lawsuit, Grocery hired Xavier, an expert on grocery store displays, to investigate the accident. His findings were unfavorable, and Grocery has not identified Xavier as a witness. Xavier is an independent contractor, but he works exclusively for Grocery. Included in Priscilla's original set of interrogatories was a question seeking the names and opinions of all experts Grocery had hired for the litigation. In response to that interrogatory, Grocery replied, objection, privileged. No information about Xavier was disclosed by Grocery. And then finally, we have the call of the question again, which you should read again at this point after having read the fact pattern. Now that you've read the call of the question and the fact pattern, you can begin writing your answer. I cannot stress enough the importance of using IRAC to organize your answer. IRAC stands for Issue, Rule, Analysis, Conclusion. So a basic IRAC would have a bolded and or underlined heading identifying the issue, then a paragraph for the rule, 1 or more paragraphs for the analysis, and a paragraph for the conclusion. And you should insert a space between each paragraph to emphasize your organization and also to make your answer look longer. And you would do this for every single issue. I mentioned earlier that some California essays have 30 or even more issues, so you would repeat this same formula for every single one of those issues. Let's talk about crafting each part of the IRAC in more detail. The issue statement should just be a word or phrase identifying the legal issue or the specific facts that you are addressing. It does not need to be a full sentence, and you do not need to write out the issue is whether. Some people like to write a conclusory issue statement. This is following the CRAC formula, conclusion, rule, analysis, conclusion. But we actually recommend that you do not start with a conclusion. Instead, just put your conclusion at the end of your IRAC. There are 2 reasons for this. First, if your conclusion happens to be wrong, you're telling the grader right up front that you're about to be wrong. and the grader is then less likely to pay as much attention to your rule statement or your analysis. So even if you did say something correctly in those sections, you might not get the credit you deserve for it. The other reason is because if you write your conclusion first and then write your analysis, you might change your mind about the conclusion by the time you work through the facts and arguments. And then you might write a different conclusion at the end of your IRAC. Now your conclusions don't match, and it kind of looks like you don't really know the issue very well. You will receive points for including a conclusion in your answer, but you don't get extra points for starting with a conclusion. So I think your safest option is to just include the conclusion at the end. In your rule paragraph, make sure you start by stating the general rule before stating any exceptions. However, you don't need to provide extraneous detail. For example, don't state every exception to a rule if only one exception is applicable. The analysis is the most important part of your answer. To write a strong analysis, first, make sure that you incorporate all of the facts from the fact pattern in your analysis. The fact patterns are usually fairly short, so every single fact is likely there for a reason and should be utilized somewhere in your analysis. You may also need to identify missing facts that would be helpful to know in order to thoroughly analyze the issues. You should not make up new facts or change the existing facts, but instead tell the grader what additional facts would be helpful to know in order to come to a conclusion. Another way to make sure you're writing a thorough analysis is to consider arguments that each party will likely raise. This is your chance to show off your arguing skills. So put yourself in the shoes of the attorney for each party and think about what each party is likely to argue and/or respond. Sometimes the facts are so clear or one party has such a strong argument that there isn't a response, and that's okay. You might not always have an argument for each side. But if you can think of arguments for each side, you should also identify who has the stronger argument. That brings us to the conclusion. Sometimes there is a correct conclusion, and sometimes it could go either way. Doing practice essays will help you identify the types of issues and fact patterns that can have a right answer and those that could go either way. Even if you don't think there is a clear right conclusion for a particular issue, you should still include the conclusion section of your IRAC. You can write something like, this issue could go either way, but it seems like the plaintiff has a slightly stronger argument, or whatever the case may be. Not concluding or just concluding, I don't know who will win, makes it look like you're just giving up, and the graders could deduct points for that. Now let's put that IRAC formula into practice with the July 2019 civil procedure essay. The call of the question included 4 distinct issues that need to be addressed. When the call of the question is specific like this, your heading should correlate to the numbered questions so that the grader can clearly see where your answer to each part of the question is. So to begin, you should have headings for each question. The first question is about Priscilla's motion to compel responses to Grocery's interrogatories. The second question asks about Grocery's motions, plural, and you can see in the facts that there are actually 2 different motions to compel. So there should be separate headings for each of those motions because the analysis is going to be different for each one. So 2A can be for Grocery's motion to compel the mental and physical exam, and 2B is for Grocery's motion to compel Priscilla's tax returns. 3 is Grocery's response regarding its expert, and 4 is for Grocery's assertion of privilege. In this case, the main headings are centered around the facts, so a short statement of the pertinent facts will suffice as your issue statement or heading. You don't need the heading to be in the form of an overall conclusion or even a full sentence. Now, because these headings are centered around the facts, we still need to identify the legal issues applicable to each question. This is where subheadings come in. If you bold and underline the main headings, pick a different typeface, like bold and italicized, for instance, for your sub-issues. This is going to help the grader see the organization of your answer. Looking at the first question, which is about Priscilla's motion to compel responses to the interrogatories, I can think of 4 legal issues that need to be addressed here. So you'll need an IRAC for each of those 4 legal issues. Each IRAC should start with a subheading. Here you can see that the scope of discovery, timing of discovery, number of interrogatories, and need to meet and confer are the sub-issues relevant to the question about Priscilla's motion to compel responses to interrogatories. The way to tell if something should be set up as a sub-issue is to ask yourself whether there is a specific rule for that issue. In this case, there is a rule for the scope of discovery. Things that are relevant and not privileged are discoverable. This is different from the rule on the timing of discovery. Discovery cannot start until the parties have a 26F conference. There's also a rule on how many interrogatories can be sent. The federal rules allow each party to send 25 interrogatories. And finally, there's a rule regarding the parties' need to meet and confer prior to filing a motion to compel. So because each of these issues has a different rule, I think it makes the most sense and will be the most organized if you break this into 4 separate mini IRACs. Now, you could include all of these different rules in one giant rule paragraph under the main heading, and then have one giant analysis section discussing all those different rules, but I think breaking it up into sub-issues is going to make it much easier for the grader to read. From here, you'll continue to fill in the different pieces of that IRAC with the substance and content. You will write in the rule statement for each sub-issue. Then you'll fill in an analysis, including arguments for both sides and any additional missing facts that would be helpful to know. Every IRAC should have a paragraph for the rule statement, a separate paragraph or paragraphs for the analysis, and then finally a conclusion on its own in a separate paragraph. When you break up your answer into sub-issues like this, you might have very short rule statements, short analyses, and/or very short conclusions. Maybe you only have one sentence for each part, but that's okay. Remember, it's okay if your writing is choppy because your grade is based on the substance and the content, not on your writing style. Additionally, by breaking each sub-issue up with a separate rule, analysis, and conclusion paragraph, you can quickly glance at your own answer and double check that you included all of the necessary pieces. If you see at least 3 paragraphs under each heading or subheading, one for the rule, one or more for the analysis, and then one for the conclusion, this is a good way to double check that you've included all of the necessary parts to your answer.